Welcome to the program, and first, today's High Court ruling that has potentially big implications for how the government will have to handle asylum seeker applications for refugee status in future, and for a political backlash. Today's ruling related to two Tamils who had been processed offshore and been refused refugee status earlier this year, and the court found unanimously that they had been denied procedural fairness. The implication of this finding is that the way is now open for many more asylum seekers to take their case to the High Court rather than the limited appeals process now. There are now claims denied by the government that the Christmas Island detention centre is redundant, but the opposition says the government's credibility on this issue has now been sunk. I spoke with Immigration Minister Chris Bowen earlier tonight. Chris Bowen, the import of this ruling is that all asylum seekers, no matter how they arrive here, no matter whether they go to Christmas Island or onto the mainland, are going to be treated fairly under the law or equally under the law. That is correct?
Well, the ruling today from the High Court is that people who arrive in an excised area will, under some circumstances, have the right to judicial review, and those circumstances would be procedural fairness and some matters of law. So it's not a merits review, it's not as if the courts would be able to go back over every particular element, but in some circumstances there would be a right for a court to review the procedural fairness or the legal situation in relation to their asylum claim.
But cutting to the heart of this, are you prepared to accept that the government has been fundamentally and profoundly unfair in the way it has sought to discriminate against offshore asylum seekers by seeking to deport them without allowing them the same rights of appeal that many other asylum seekers have just because they happen to make it to the mainland?
No, I don't accept that, Kerry.
But is that not the implication of this ruling?
No, I don't believe it is. This government, of course, introduced the independent merits review, which is, if you like, is a form of appeal for people who've arrived in an offshore place. The High Court has today said that in some circumstances there should be a right for a further appeal on some grounds, and they are procedural fairness and matters of law.
Now, the opposition says that it is that change by your government in 2008 which has opened this up.
Yeah, well, that's their spin, and that's not correct. And I've seen, for example, Professor Williams knock that on the head today as being incorrect. I don't want to get too technical, but it's important to note that this ruling from the High Court is based on the fact there is detention and based on the fact that ministers automatically lift the bar as a matter of course. Now, we have lifted the bar for people who've arrived on an offshore island to claim asylum as a matter of course, and where it was relevant, the previous government did that as well. So I think Mr Morrison and Mr Abbott are engaging in that spin, but it doesn't bear analysis under the facts.
Do you accept the possibility, the implication of this ruling, that it could open up deportations going all the way back to Tampa?
No, I don't think that's necessarily the case.